this
39B and C also not comprehend a law? I mean, it's not a power. No, part 4 is not a power at all. Part 4 is only an object. It's hortatory, as we call it. It's a goal. But when Article 39B says that the ownership and control, the state shall secure its policy towards securing that the ownership and control of the material resources of the community shall be so distributed so as to subserve the common good.
Yes,
does this not also factor in the reasonableness of a law which also provides for acquisition so that you will distribute?
No, Lord, I would readily agree with your Lordship.
It would be very technical to say that this does not allow the state to justify a law of acquisition on the ground that what this contemplates is only distribution of what you already have.
No, Lord, I would respectfully agree with your Lordship. Lord, I think that would be an over-technical view, and that is not a submission I make. But Lord, the point that I do wish to make to your Lordships is that the problem with regard to private interest, that part of the problem with 39B is solved elsewhere through the constitutional mechanism, through the power of acquisition. If there is a policy and the policy translates into a law which is made under the legitimate use of 246 towards the pith and substance of 39B, adhering to all the principles of acquisition, the question does not arise.
And if there is an acquisition, it would squarely come within the concept of material resources of the community.
Yes. Now, but I'm just going to address
because that is going to be distributed for the common good.
But yes. But so I'm just going to
here that in a minute. Distribution from A to B. That is your case.
That is once again, my lady has hit it on its nail, because, my Lord, I also have put one part about the limits of this doctrine. And, my Lord, perhaps the most enthusiastic proponent of this document, Justice Krishna Iyer himself, in Bhim Singh Ji says that the limits of this doctrine are reached when you try to distribute from private party A to private party B. And that is actually what we are concerned with in the challenge.
But that is not the question before us.
Yes, that is not a question before your Lordship. I quite see. But not in trying to assist your Lordship on what we should do and what we should say with regard to 39B, I wanted to point out to your Lordships, or 2 or 3 things in my note. But I do want to indicate the outer boundaries of this document.
Yes.
But the outer boundary of this document is it does not contemplate an exchange of these material resources between 2 sets of private individuals. No, that my learned friends hasten to add is the only question. It's the only question in the challenge which will now take place after your Lordship send it down to an appropriate bench. Yes, of course it is.
Let me also not be strictly correct. The idea is sometimes you are redistributing wealth from those who have a monopoly over wealth. That's what you did that's what our land reform laws did, to redistribute wealth from the zamindars to the tillers. So it was really from one set of private individuals to another.
Well, or once again you were... No, once again... Oh, your Lordship's point is very well taken, my Lord. But the only thing I would add to that is, my Lord, those acquisitions were done pursuant to the power to acquire under the Constitution and for a particular purpose, agrarian reform, which is now well known. So 31A, 31B and 31C really can be fully understood if we read them together. But I do accept that, and what that is a part of my note. Could I just read now 4 or 5 paragraphs of my note, and I am done.
Under those laws of agrarian reform, all these lands first stood vested in the state. It became community resource. Then the tiller had to file an application seeking occupancy right. And if he is really the tiller, then order is passed by the land tribunal to give it to the tiller.
I am deeply obliged to my lady.
And not directly to the tiller.
Exactly the point I want to make with regard to acquisition. That actually it is not such a problem if we intersperse the concept of acquisition. Lord, this argument which has been made thus far on my part as well, Lord, has left out that part. Lord, it is important to understand this directive principle in the context of the power to acquire. Under 300. Now, Lord, I have kept your Lordship so long, Lord. Can I just show your Lordship about 4 or 5 paragraphs and I'm done, Lord, with this note.
Yeah.
But may I take your Lordship, Lord, to my note at page, just to indicate at page 124. Lord, at 124, in the first 3 paragraphs, I've dealt with the Mafatlal judgment. But there I've made the point that I have made to your Lordships with regard to obiter. I sought to make a second point also, that the judgment is totally distinguishable. But it deals with unjust enrichment and the distribution of tax. So it is totally different. But in my respectful submission, the reference was rightly made and your Lordship ought to entertain it. Now, Lord, the second set of points 4 and 5, what is what I have said with regard to 300A. If I can just read my formulation in paragraph 5.
Yes.
Once the property is acquired with the authority of law, the question with regard to the inclusion of private property within the sweep of 39B falls away. The petitioner submits that the acquisition with the authority of law of private property may be pursuant to a policy formulated by the state under 39B, to my lord's point, and the distribution of ownership and control thereof may be in accordance with the principles of Article 39B. Now, Lord, some suggestions to your lordship about how we will deal with the observations on 39B I have sought to make here. Your lordships may consider them. The debates of the Constituent Assembly with regard to 39B make it evident that the language of the articles in Part 4 was deliberately drafted to ensure they were not given a fixed or rigid form, but could be fundamentally changing, having regard to the circumstances of the time. Lord, I refer to the speech of Mr. Ambedkar. But it is relevant that the Constitution also provided for fundamental right of ownership to property, Article 19(1)(f) and 31 at its inception. The Constituent Assembly was therefore fully conscious of the fact that private ownership of property was then a fundamental right. As is well settled, it is also a part of the constitutional scheme that the fundamental rights and directive principles of state policy were to be balanced against each other. But Minerva Mills. Despite the socialist aims of the Constituent Assembly in incorporating the directive principles in Part Roman 4, private property was also respected as a fundamental right. Article 39B provides for the distribution as best to subserve the common good of ownership and control of material resource of the community. The expression material resource of the community, now this I want to stress, is a composite expression, and each word is a necessary ingredient of the same. To determine if the requirements are met, it is necessary to consider each of the ingredients being met individually and in the aggregate. But that's paragraph 9. But paragraph 10. But the expression, so but it is necessary to meet each of the conditions individually, but also in the aggregate. So it is a self-limiting provision in one sense. It is very difficult to find something which meets each of the criteria in aggregate, all of them, not and or not one of them, but each of them for every part of this particular Article 39B. Not the expression para 10. The expression material resource of the community must also be in accordance with the intentions expressed by the members of the Constituent Assembly, be interpreted not in a fixed or rigid form, but in a manner which is fundamentally changing. Now, about my submissions. But it is submitted that 39B has been deliberately given the language that it has to maintain its open texture, to give it flexibility, to adapt to changing constitutional and social values. But keeping with the spirit of the Constituent Assembly and the manner in which 39B has been drafted, it ought not to be limited and stroke or straitjacketed and stroke or canalized. It is preferable to test each individual case against the ingredients of 39B, keeping in mind current constitutional and social values, not to give a particular temporal interpretation to the article. Current constitutional and social values, i.e. the importance of private property, my Lord the Chief Justice said repeatedly, enshrined in 300A, and the importance to the role of private enterprises, my Lady Nagaratna referred to it repeatedly. The sweep of Article 39B provides that the distribution must be to best serve the common good of all. All of these considerations must be cumulatively considered on a case-to-case basis, but the aspect of community was repeatedly stressed by my Lord the Chief Justice, by my Lord Justice Dhulia, repeatedly, that it has to have a community element to this. The limits of 39B may also be borne in mind. Justice Krishna Iyer himself in Bhimji Singh's case stated that the whole story of Ms. Agarwal, Ms. Jethmalani and Ms. Bisni are a part of the team who worked very hard on this. My learned solicitors, Mr. Jadeja and Mr. Unikrishna, and of course, my learned seniors who your lordship will.
Thank you. Please give our compliments to the entire team of your juniors who worked very hard.
Deeply obliged to your lordship. It's been a great privilege for us. Please.
My lord's permitted one. Sorry, can I?
1 second, my learned brother.
That's it.
No, Mr. Andarjun, I think you are leaving for Mumbai today, right?
But I don't have to if your lordships want me to.
No. In fact, perhaps when you go back home, you have young children.
I do, madam.
All right, they might ask you, Papa, what were you doing in Delhi? Right, so you will say that I have gone and argued a case So the children is curious, might say, what was the case all about? You can't be talking to him or her, 31C, 39B. You will say that we are discussing a case which relate to cheese. The other side, the uncle from another uncle was saying that the cheese had sweet cheese, it had holes. I was saying that it was a Amul cheese which does not have holes.
But I take your lordship's declaratory point on this, but I treat it very seriously. I'm deeply obliged to you. Let's.
Yeah, I
request for clarification. Petition 660 and other petitions related to Rent Act were also on board, my lord. Just like to know.
We are going to answer the point of reference with a bench of 9 judges, and thereafter it will be placed before the regular bench for hearing the challenges.
Could I make a small prayer, my lord? I not done before constitution. But given the fact that these have been languishing from 92, my lord, till today, and they're still getting 1949.
After the reference is disposed of, you can move the Chief Justice in the administrative capacity, and the matters will be listed assigned to the regular 2-judge or 3-judge bench of the case.
I wanted, my lord's
It will
permits.
have to go before a regular bench, right? 3-judge bench. Doesn't have to then go before a 5-judge.
Yes, Lordship, I wanted 1 minute of my lord's time,
Yes,
my
yes.
lord's permit. There's a note 1I. I just wanted to point out what are the 4 points I've made. I'm not going to argue them, but just to place them. One, my lords, on 31C we made, I've described, etc., and given details. That was a short, so to say, departure of the balance between part 3 and part 4. From 1971 to 80, 71, 31C came in, and 1980 it was declared void. So there is no vacuum or void. It was for a very short period of 9 years that it survived. Then on 39B, I have also given the rules of interpretation of constitution, harmonious construction, etc. I just want to make one last point, and that's I'll close at that. I've described all this interpretation of 39B. But what 39B says is so distributed. It doesn't say distributed. Now, so distributed, as many of my lords mentioned, for example, airwaves. Airwaves, only 2 players is for the common good. Electricity, sometimes a monopoly is for common good. In some cases, it is many. So distributed is not what the respondents argued, namely give it to everybody.
No,
You
they
can't.
didn't
So therefore,
argue that at
you
all.
have to see what is in public interest,
You
and
can't
therefore,
dispute. I mean, these are, the
Lordship.
spectrum has to be necessarily, it's
Lordship.
always.
Absolutely.
There are few
Facts
players who-
and
And
context.
therefore, in my note, I've given using the rules of interpretation of a constitution, I've given my submissions on 39B.